Our focus today is on company directors, and we'll be asking ourselves who these directors are, looking at the procedures for appointment of directors, looking at their qualifications, right? Looking at the rights and the duties of directors, and also looking at the powers that they have or that they hold. To start us off, I think there are those who have not joined us yet. You have to keep on animating them. I don't know what is happening. Anyway, we continue. So we start by looking at the meaning of director. And a director is in a person occupying the position of a director. Simply put, and in this case, we are using a director to define a director. We're saying a director is any person occupying the office of director. I'm not sure whether we're getting this. I need to put the next one for everyone in the meeting. No one occupying the office of a director. Good. So much noise. Now, one is a director because of the position of the office and its duties. Simply that what that statement means. That you become a director because of the position that you occupy in that office and because of the duties that you perform. You become a director because of that. Now, there's a case of Forest of Dean Mining Company of 1878. In that case that is there, in that case that I've pasted there on the chart, you're able to access it. One of the judge, Jessel Emar, said that does not much matter what you call them, so long as you understand what their real position is. Jessel, one of the judge in that case, said, and I quote, "It does not matter what you call them, so long as you understand what their real position is, which is that they are really commercial men managing a trading concern for the benefit of themselves and for the benefit of the shareholders." Close quotes. So that is a case that where there was a contention on who a director is or who a director is not, right? And that is what the judge said. Now, in another case of 1962, let me put it here again. You can have a look at it later. Of R versus Camps. Judge of the Court of Appeal, Judge Sinclair, affirmed that a person occupying the position of a director, though not duly appointed, is still held a director. A person occupying the position of a director, though not duly appointed, is still a director as long as you are in that position. It is the position that makes you a director, and not just necessarily the appointment, right? It's not necessarily the appointment that will make you a director, but the position itself is what will make you or makes you a director. Now, having looked at the definition, how are people appointed as directors? So we look at the appointment of directors, appointment of directors. Now, directors may be performed in, may be appointed in different ways. May be appointed in different ways. They may be appointed in different ways. And one of the ways of appointing a director is, of course, the first company directors, the first directors of the company. That is one of the ways of becoming a director. The first directors of a company. Now, the first directors of a company are appointed by promoters. I hope we've not forgotten the work of the promoters. We covered this as one of our first topics, right? So the first directors are appointed by the promoters. And where the promoters have not appointed the director or directors, right, subscribers to the memorandum will become and will be regarded as the first directors. And therefore, that should be very, very clear. That if the promoters have not appointed the directors, then those people who have subscribed to the memorandum will become the first company directors. So that is one of the ways through which one becomes a director. Number two is what we call subsequent appointments. Number two is what we call subsequent appointments. And simply what we mean here, this is when a director or a person is appointed when the company is already in existence, right? It's not at the beginning, when the company is already in existence. And of course, the company will make this appointment in the following ways. The company can make these appointments, subsequent appointments, in the following ways. One is when they want to replace, directors who have retired on a rotational basis. When they want to replace directors who have retired on a rotational basis. Number two is to replace directors who have been removed from office. Because sometimes you can be removed, not through retirement, but through an action of the company or company's board. Companies, maybe AGM, can decide to retire you, to remove you from office. Number three is to replace those directors who have retired. To replace directors who have retired. And number four is to replace the directors who are deceased. To replace directors who are deceased. Now, the third way through which one can become a director of a company is what we call casual vacancies. Casual vacancies. Casual vacancies. And these are vacancies that occur in the ranks of directors anytime before the next annual general meeting. Any vacancy that occurs before the next annual general meeting, then a director must be appointed. A director must be appointed to continue with the work of the director until they are ratified or they are replaced in the next annual general meeting. Of course, those casual vacancies may arise because of many issues, be it death or otherwise. And therefore, the appointment there is done by the existing directors. It is done by the existing directors. Now, we also have what we call alternative directors. We have what we call alternative directors. And these are directors appointed temporarily to represent the director during his absence or inability. Right? We have alternate or alternative directors. And in case one of the director or two of them are not well, either under medication or they are not available for a specified period of time, then they can appoint people to represent them and to do their work as directors. We call them alternative directors. Now, what are the qualifications? What are the qualifications of directors? What are the qualifications of directors? What would it take for you to be appointed a director? What would it take for you to be appointed a director? Now, the Act, the Companies Act, does not require a director to hold shares. Does not require a director to hold shares. Thus, one can be a director, anyone can be a director unless the articles provide otherwise. Anyone can be a director unless the article provides otherwise. Now, Article 77, Table A. Article 77, Table A provides that share qualification of directors may be fixed by the company in a general meeting, in an AGM. It provides that share qualification may be fixed by a company in their AGM. And unless it is fixed, then no qualification shares shall be required. No qualification shares shall be required for one to become a director. If the articles of the company contain a provision that the qualification of a director shall be holding of a specified number of shares, then there are specific provisions or rules that must be followed. And I hope we are getting what you're saying. That many qualification shares are simply the shares that the minimum number of shares that a director is supposed to acquire for you to become a director of a company. That can be inserted in the articles, right? If it is inserted, if it is not inserted, if the articles does not say the number of shares that you're supposed to hold for you to become a director, then it is not compulsory for you to hold any share. But if it is included in the article that for you to become a director, then you must hold what we call qualification shares, then there are some things that you need to abide by, some things that you need to note. And the one is that each director must acquire and retain such qualification shares as guided by the articles within 2 months after appointment. So which means if the article says that a director must have what we call qualification shares, you only have 2 months, right? You only have 2 months to acquire them. Now, number 2 is that the share warrant to bearer may not count as qualification shares. Share warrants, we have looked at this before. Share warrants will not count as qualification shares. Number 3 thing that you're supposed to note here, who want to join? Number 3 thing that you're supposed to note here is that if shares are not acquired within 2 months, then you will cease to be there to be a director. Remember, on the point number 1 where we have said that you have 2 months. If you do not acquire those shares within those 2 months, then you will cease to be a director. You will cease to be a director. Number 4 is one cannot be reappointed unless he has obtained his qualification shares. That if 2 months lapses and you've not taken up your qualification shares, then it means that you cannot be reappointed. You cannot be reappointed. You cannot be reappointed unless you acquire them. Then the other thing is a fine of 100 per day will accrue for the period in office without qualification shares. That for those 2 months that you've been given, for any day that you've not taken your qualification shares, then every day you'll be required to pay a fine of 100 shillings per day. 100 shillings per day. What are the age limits of directors? Do you have age limits? Is there anyone who cannot become a director? Yes, of course we have age limit. Now every director must retire on or shortly after the achieving or reaching the age of 70 years. Every director must retire on or shortly after the 70th birthday. Yeah, but you can continue if allowed at a general meeting and after special notice has been given. That even if we say that retirement age is 70, you can still proceed. If the company still needs you, you can still proceed if it is ratified by the annual general meeting, and if a special notice has been given for the same. Now, the minimum number of years that you must have for you to be appointed a director is 21 years. 21 years. 21 years. However, it is good to note here that the limits do not apply for private companies. They do not apply to private companies. And therefore, private companies, you can become a director even before you reach the age of 21. You can become a director even before you reach the age of 21. Now I know some of you are within that bracket, and some of you are still not there, till 18 years. 18 years, 19, and 16. So some of you qualifies to be appointed public directors, directors for public companies. Others can only be appointed as directors for private companies, and therefore it is important for us to note that. It's important for us to note that. Even if you allow, take 1 minute break. I sort out something here, then we continue. Declared bankrupt. If you are declared bankrupt, then you cannot become a director. You cannot become a director of a company. It is important for us to note that. Now, what is the effect of disqualification? What is the effect of disqualification of a director? Now, the act of a director or manager shall be valid notwithstanding any defect that may afterwards be discovered in his appointment or in his qualification. Those acts that are done after disclosure by the company will not be binding to the company. But if they have been done before, as long as they are within the powers of the director, then they will bind the company. What are the grounds for disqualification of a director? What are the grounds for disqualification of directors? What are the grounds? What are the grounds for disqualification? What are the now, my friend, who is this? From Neon Nova. What is Neon Nova? How did you even get in here? I'm supposed to lock you out. I'm supposed to lock you out. Neon Nova, I'm supposed to lock you out. You cannot log in with the name of your phone. You can't. You can't. I will not allow that. Good. So we proceed. We proceed. We proceed. And we are looking at the grounds under which you can be disqualified. Grounds under which you can be disqualified from becoming a director. Number one is failure to take up the prescribed share within 2 months. We have already seen that. If you fail to take up your qualification shares within 2 months, Section 183 says that you'll be disqualified from becoming a director. Number two, Section 188 talks about being disqualified when you become what? Bankrupt. When you become bankrupt, then you will be disqualified as per section 188. Number 3 is if you're prohibited from being a director for any other reason. If you're prohibited from being a director for any other reason, if you're prohibited from becoming a director for any other reason, as that is addressed by section 189. Number 4 is if you become a person of unsound mind. If you become a person of unsound mind. Number 5 is if you resign by notice in writing to the company. If you resign by notice, if you resign by notice in writing to the company, you cease to become a director. Number 6 is what we call absence from office without permission for more than 6 months. Absence from office without permission for more than 6 months. If that happens again, you cease to become a director. You cease to become a director. Hope that is clear. When can one be removed from being a director? You've looked at the grounds. Now, you can either leave office of a director, 1, by vacation, or 2, you can be removed from the office. Vacation or removal. You can either be vacated or removed from office. Now, vacation of office arises when a director voluntarily quits the office for whatever reason. Yeah, for whatever reason, you can decide to quit, right? And if you quit, you'd be liable for all the acts that you committed while you were in office, but you'll not be liable for any act that is committed thereafter. I hope that is clear. We are saying number 2 way is the removal from office. And there are some times that you can be forced to quit, not voluntarily in this case, but you are forced by the situation or by law to quit. And this can only happen in 2 ways. One is operation of law, and the other one is by the company. And operation of law can remove you from office when there is a breach of your statutory qualifications. When there is breach of statutory qualification. And number two is when the company is liquidated, or where the company is liquidated. The law states that you are removed, or you vacate the office, you are removed from the office. Then the second way, apart from that operation of the law, is when the company itself, through an ordinary resolution, after they have given you a notice, they can remove you from office. They can remove you from office. Can remove you from office. Now, what is the position of a director? What is the position of a director? What is the position of a director? Position of a director. Now, the position of a director can be considered or described from different perspectives. It can be considered or described from different perspectives. And the one, you can see directors as agents, right? Can see them as agents. Can describe it from that perspective of being an agent. And a company is an artificial person. That one we already said. And therefore it cannot act itself, right? Being an artificial person, the company cannot act on its own. It must therefore act through agents, right? It must act through agents, and these agents are the ones that we are calling directors, right? In the eyes of the law, they are agents of the company because a company is an artificial person who cannot act on his own, right? They cannot act on their own, and therefore they can only act through the agents, right? Now, the general principle of law is that of the principal and agent. The general principle of law is that of the principal and agent. And this is the one that regulates, in most respects, the relationship of the company and its directors. It is the one that regulates, in most of the instances, the relationship between the company and directors. The directors are not personally liable for the contract which they make for the company. They are not personally liable. As agents, they are not personally liable for the contracts which they make for the company, provided they act within the scope of the authority, right? And do not make the contract in their personal interest and name. As long as that is done, then they will not be liable. They will not be personally liable. If they exceed the powers given to them by the memorandum of or the articles, they will be liable for breach of warranty of authority. In case they breach the memorandum, then they will be liable for breach of warranty of authority. Now, the shareholders may ratify the act which are intra vires. They may ratify the acts which are intra vires the company, which means that if they are within the scope of the director in terms of authority, the company, even if they were not sanctioned by the company in the first place, the company can adopt them and ratify them. But if they are ultra vires, which means they are beyond the powers of the directors, the company cannot ratify. They can never be ratified because you cannot ratify that which is outside the law. You cannot ratify that which is outside the law. It's also important for us to know that directors are not just agents, because they have what we call independent powers in certain matters. They can have what we call independent powers in certain matters. We look at directors as employees. Can we say that directors are the employees of the company? Can we say that directors are employees of the company? Now, although that we have said that the directors are agents of a company, they are not considered employees or members of staff of the company. They are not considered as employees or members of the company, and therefore are not entitled to privileges and benefits that comes with employment. And therefore they are not entitled to privileges. They are not entitled to privileges that comes with employment as staff. Having said that, I also have to say that there is nothing that can prevent a director from being a servant of a company under special contracts, right? Which means if you are a director, you can still enter into a contract with the company for employment, right? You can still work for the company under special contracts, even when you are a director. I hope that is clear. Third one is directors or director as officers. Directors as officers. Now, for certain matters under the Companies Act, directors are treated as officers of the company. And as such, they are liable to certain penalties if the provision of acts are not strictly complied with. They are not strictly complied with. Therefore, they can still be treated as the officers under specific instances. And number 4, we look at the directors as trustees. Directors as trustees. Directors as trustees. And the directors are treated as one, trustees of the company's money and property. Trustees of company's money and property. And number 2, they are treated as the trustees of power entrusted to them. They are treated as trustees of power entrusted to them. Now, it's important to know that the directors are trustees of the company, monies and property, because they must account for all the company's money and property, right? They must account for everything that belongs to the company. And they are to refund the company any money or property which have been improperly paid away or transferred, right? So in case they recklessly or through fraudulent means transfer property to themselves, they'll be compelled by law to return those properties to the company. Now, the fiduciary duty or position as regard to the protection of the company property means that they are not to profit. They are not to profit themselves personally from the property of the company, right? We had seen that. And we also see that they have the fiduciary duty to be honest to account for the profit of the company. They have to be honest to account for the profit of the company. Now, directors are trustees of powers in the sense that they must exercise their power honestly and in the interest of the company and the shareholders, and not in their own interest at any given time. They must be able to use that power in the interest of the company. Now, there's a case here of Pierce versus Mills of 1920. Pierce versus Mills of 1902 or 1920. Check this. Pierce versus Mills. It's a case there that is dealing with these things. And in this case, the directors of the company had powers. They had powers to issue the unissued shares of the company, to issue the unissued shares of the company. The company was in need of further, sorry, the company was not in need. It was not in need of further capital. Remember, the directors have been given power to issue the unissued share capital. But in this case, they issued the capital, right? They issued the shares. But at that time, the company was in no need of further capital. The company did not need any other capital at that particular time. But the directors made a fresh issue to themselves and their supporters. The directors, knowing this, made a fresh issue of shares to themselves and to their supporters with a view of maintaining control of the company. Right? They did that because they wanted to control the company. So they issued shares to themselves and to their supporters. But remember, they had power to do that, right? But it was to be coupled with the fact that the company needed the capital. But in this case, the company did not need the capital. When this case went before the judges, it was held that the issuance and allotment of the shares was void. It was void because it was a case of self-interest. They wanted to benefit themselves. And therefore the case was, the shares allotment was void, null and void. Now, directors are trustees of the company and not for the individual directors. They are directors of the company. It is important for us to note that. They are not directors, they are not trustees, they are not directors or trustees for individual shareholder, right? We must be able to differentiate between the individual and the company. We must be able to differentiate between the individual and the company. And therefore, they are not trustees for individual shareholders. Now, there was a case of Passivo versus Wright of 1902, which again is important. It is important that you were able to look at these cases and get the background information. There's that case of Passivo versus Wright of 1902. The directors of a company bought shares from the shareholders while they were negotiating the sale of the company to another at a very high price. But of course, they did not disclose this fact to the shareholders, right? They did not disclose this fact to the shareholders. No, this case is to demonstrate that the directors are regarded as trustees for the company and not for individual shareholders. And therefore, what happened in this case is that the directors wanted to sell the company, right? And because they wanted to sell the company and the person who was buying the company had given a very high price, they decided to buy shares from individual shareholders, so that if you are a shareholder, they come to you and tell you, now, why don't you sell me your shares at this amount? And of course, people sold. Some of the shareholders sold. Now, later on, they went to the court. I guess it is when they realized that they were shortchanged, that the shares were supposed to be very costly and expensive. They went to the court, and when the court listened, it was held that the purchase of shares was good, right? The purchase of shares was good, and that the correct view is that directors stand in fiduciary relationship to the company and not to the individual shareholders, right? And therefore, they have no duty of trustee to these individual shareholders, right? They are not bound to the individual shareholders. How are the directors paid? So directors remuneration. Directors remuneration. Now, the remuneration payable to director of a company, including any managing or whole-time director, will always be determined by the articles of the company or by a resolution passed at the annual general meeting. That is the only way. That is the only way through which a director can be paid. Either the article says that we should be paid a specific amount of money, or alternatively, it is passed by a resolution at the annual general meeting. I hope that is clear. Because directors have no right to be paid for their services, and they cannot pay themselves, right? cannot pay themselves, they cannot pay each other. Yeah. However, any expenses that they incur when they are in the business of the company, they must be paid. Any that occur when they are in business, it must be paid. Must be paid. Must be paid. Somebody is asking, what about private companies? What about the private companies? Angela. The directors are directors. You cannot be paid unless it is passed or you pass it at your meeting, your normal meetings. You still have the resolutions and board meetings. Unless you pass it there to be paid, that's when you will be paid, right? Or when you put it in the articles. Directors, or you want to become a director, you qualify for this amount of money every month. Put it there. If you put it there, then you will be good. You will be good. The other thing that we need to look at is the director's duty of disclosure. Director's duty of disclosure. Director's duty of disclosure. And we start by looking at the contract in which directors are interested. Contracts in which directors are interested. Remember, directors are also individuals. And considering that they are the top managers of companies, and those companies have some deals and have some businesses they need to do with the population, and you are not paying them salaries, probably there will be those contracts where they will be very much interested, in. There are those contracts where they will be very much interested in, and therefore we want to see what are the director's duty of disclosure. Now, a director must not enter into contract with a company, except with the consent of the board of directors, right? The board must consent, they must agree, must give a go ahead, right? And therefore, it can either be for the sale or purchase or supply of any goods, material, or services, right? Or for undertaking the subscription of any shares or debentures of the company. That must always be given. Consent must always be given. However, there are exceptions. And the exemptions that you have here will be that the contract for the purchase of goods from the company or sale of goods to the company for cash at prevailing market prices would be exempted, right? So we are saying that they are not supposed to enter into a contract unless, of course, it is consented to by the board of directors. Here we are saying now, if you are buying or purchasing and supplying things for them at the market prices, at the prevailing market prices, which means you are not gaining much, and then you can be allowed to conduct business with the company. If there are contracts for sale, purchase, or supply of goods in which either of the parties does business, then in that case, it would be allowed. Any transaction of a banking or insurance company in the ordinary course will also exempt you. From the above rule that we have discovered or that we have talked about of the contract in which directors are interested. In which directors are interested. We also have what we call disclosure of interest by director. a disclosure of interest by director. Now, every director of a company who is directly or indirectly concerned or interested in a contract or a proposed contract by one of the company that they represent must disclose the nature of his concern or interest at meeting of the board of directors. Such that if you're a director of company YZ and you're interested in one of the businesses that they do, if you have to do that business, then you must make it known to the other directors. You must make it known to the other directors. The common sense rule of law is that whenever personal interest of a director conflicts with his duties towards the company, it must be disclosed. It must be disclosed. That one must be, it must be disclosed. Interested directors, interested director of a company, of course, stands in the fiduciary position towards the company and is bound to protect the company's interest. They cannot therefore place themselves in a position in which their personal interests conflict with the company. You cannot place yourself in such a situation where your personal interest conflicts with the interest of the company. Now, you must not, you cannot vote as a director on any contract or arrangement in which you are directly or indirectly interested, unless the company authorizes you in the articles. You cannot vote, you cannot participate in those votes where you are interested, right? And in case you vote, then your vote should not be counted. In case you vote, your vote should not be counted. And of course, again, we say that your presence will not also count towards the quorum. It will not count towards the quorum. Now, the quorum must comprise directors who are entitled to vote the particular matter before the meeting, right? Therefore, as an interested director, you cannot be allowed to vote. What are the legal effects of non-disclosure by interested directors? What are the effects of non-disclosure? What are the effects of non-disclosure of interest by directors? Now, these are of two categories. One, we have statutory consequences. Number two, we have common law. We have common law consequences. Now, under statutory consequences, Section 200 says that directors shall be liable to a fine not exceeding 2,000 shillings. Say that directors will be liable to a fine not exceeding 2,000 shillings. And under common law consequences, the contract itself becomes voidable at the instance of the company, which means the company can decide to do what? Not to ratify. It is voidable. They can avoid that contract, right? Can say, we don't know you. Never entered into a contract, right? Therefore, the director in question who also made secret profit on the contract must refund the same to the company. If you become a director, then you make profit out of the contract of the company. That money must be returned. You'd be forced by the company to return that money. I hope that so far so good. I hope that so far so good. Unless there is any question there. Any question there? Any question? Any question? Give you 1 minute, or everything is okay. We can proceed. We can proceed. Proceed if everything is okay. Kindly check. Any question? 1 minute. My network. Yes, directors can be personally liable for companies' debt. They can be personally liable for companies' debt. We'll see that later on. Voidable, we are saying that the company can fail to ratify. Can fail to ratify. It is because you're writing. I suspect you're writing. That's why you're not hearing what I'm saying, and therefore you want me to repeat so that you can write. We have said that there are legal effects of non-disclosure. If, as a company director, you don't disclose your interest in any contract, then under the statutory consequence, you'll be fined, right? You will be fined. And under common law, it means that if you not disclose, the contract becomes voidable. I don't want to go into company law. Kindly check what that means, where a contract is voidable. Kindly check what that means from a business law. It should be from business law. And that is the law of contract. When a contract becomes voidable, what are the consequences? You can check that. Can have answered that. Good. We proceed and look at the duties of directors. Duties of directors. Now, directors occupy a very key position in the management and administration of a company. They occupy a very key position. They occupy a very key position. Let's see this. They occupy a very key position in the management and administration of the company. Their duties are usually regulated by the articles, right? What they do will be regulated by the articles. Can a person be appointed as a director without a, what is without a dean? Without a dean, what do you mean? DIN. Good, we proceed. You tell us what you mean. You proceed. We have said that their duties are usually regulated by the articles. It is the article of the company that regulates your duties. Now, there are also statutory obligations on the directors. There are also statutory obligations on the directors. And therefore, the fiduciary duties of directors are basically identical with those of any person in the fiduciary possession. They must be able to exercise their powers honestly, right? And in the interest of the company and the shareholders. They must not place themselves in a position in which there is conflict of interest with the companies, right? They cannot place themselves in such positions. We know we've covered what fiduciary duties mean, right? We have covered what fiduciary duties mean. Number two is what we call duty of care, skills, and diligence. Duty of care, skills, duty of care, skills, and diligence. Now, this means that the directors should carry out their duties with such care and with such skills and diligence as is reasonably expected from them. No, we don't expect you to. The way you tell people, we don't expect you to do this or that. And therefore, as a directors, you need to act within those limits. You need to act within the limits of duty, of care, skills, and diligence. Of course, this duty of care, skills, and diligence will vary from one company to another, of course, based on the type and the nature of the work, or the division of powers between directors and other officers, or sometimes because of the usage in the past and the customs of a company. Other duties other duties of our directors will include to attend board meetings, two, duties not to delegate their functions except to the extent authorized by the Act. Number three, they have a duty to disclose their interest. They have a duty to disclose their interest. They have a duty to disclose their interest. The question is it a must for a director to be a majority age? What did we say? We've already addressed this. Jaika, you've come into class late. We've already addressed that. We said the age limit is between 21 and 70. However, there are exceptions to such. There are exemptions to such, not the age of majority. The age of majority is 18 years, right? Unless it is a private company, you cannot be allowed to become a director at 18 years, unless it is a private company, right? Good. What are the liabilities? What are the liabilities of directors? What are the liabilities of directors? One, we look at the liabilities to third parties. What are the liabilities of directors? You can divide them into one, the liabilities to the third parties. Number two, the liability to the company, right? We split them into two. You can either be liable to third parties or to the company itself. Now, under the Companies Act, this can occur in connection with the issue of prospectus, which does not contain the particulars requested by the Act, or which contain materials that are what we call misrepresentation, right? Any material that is a misrepresentation of the true facts can make you liable. Now, let me try and see whether I put this one here because I don't want to confuse you. We have said that we are looking at the liabilities of directors, and we have said you can either be liable to the third parties, right, or liable to the company. So we look at the liability to the third parties, and liabilities to the third parties can either occur or can either be found under the Act, right? Can either be found under the Act or independently of the Act, or independently of the Act, or independently of the Act. That is liability to the third parties. And we have said under the Act now, that is where we are, the discussion is under the Act. This cannot, under the Act, it will occur in connection with the issue of prospectus. And it will occur if that prospectus does not contain particulars that are required as under the Act, or where you have made what we call material misstatements, where you've made material misstatements or misrepresentations. And therefore, under this case, the directors must or may also incur liabilities. Directors may also incur liabilities when they fail to repay application money if minimum subscription has not been disclosed. If the minimum subscription has not been disclosed and they fail to pay the application monies, then they'll be liable to the third parties, right? They'll be liable to the, remember when people apply for shares, they pay some amount of money. And in the normal sense of the application, it's not everybody who applies that money or applies for the shares will get the entire shares they applied for, right? And therefore, it means that the directors are supposed to return the excess money to the individuals who had applied. In case they don't do that, they will be personally liable. Number two is when they make irregular allotment of shares. If the allotment of shares is irregular, then they'd be liable. They'd be liable. Now, under the second one, that is independently of the Act. Independently of the Act, the directors as agents of the companies are not personally liable on contracts entered into as agents of the company, right? They are not personally liable on contracts that are entered into as agents of the company. Whatever the liability that would touch on them as agents is liability of the principal, and therefore the liability is that of the company because they are agents. However, it is good to note if they fail to exclude the personal liability, for instance, while they are signing a negotiable instrument without mentioning the company's name, right? They will be personally liable. If they fail to exclude their personal liability and they are signing a negotiable instrument in their own name, they will be personally liable. Number two is the liability to the company. You've discussed the liability to the third party. The liability to the company. The liability to the company. And the liability to the company can occur either where there is ultra vires act, Number two is where there is negligence, And number three is where there is breach of trust, Number four is what we call misfeasance. Let me put this to perspective. Misfeasance. I don't know how you pronounce that in a better way. Misfeasance. Now, those are some of the circumstances. When it comes to the liability of the company. And the ultra vires simply means that it is beyond the powers of the directors. And we say that directors are personally liable to the company. They are personally liable to the company in respect to the Ultra Vires Act. And it is necessary to prove fraud in such cases. It's not necessary to prove that there was a fraud. Probably it was well meaning, it may not have been a fraud, but they did something that was beyond their powers, right? And if they do that, then they'd be personally liable. Number two is on negligence, and the onus of proving that the directors did not act in good faith lies in the person who is challenging the act of the directors. Therefore, in case you are able to prove that they were negligent, then they'll be personally liable. Number 3 is breach of trust. The breach of trust, for example, the company does not expect them to make profit out of the business that they deal with, or the business of the company. If they make their personal secret profit, then they will be liable, and that profit will revert to the company, right? And the fourth one we said about misfeasance, and this means misconduct of directors that may lead them to be sued in a court of law. Now the ultimate thing here is to prove that these acts were done in a willful way or in willful manner. They were willing to do it. They were willing to do it. We may also have what we call liability for acts of his co-directors, right? Liability for the act of his co-directors. And we say that the director is not liable for the act of his co-directors or other directors of the company. You not be liable as a director for their action. As long as you have no knowledge of them and they have kept it from you, then you will not be liable for their act. Yeah, basically because you are not their servants or agents, right? And they cannot therefore impose liability on you. They cannot impose liability on you. Good. I want to mention something about the secretary of the company secretary for the next few minutes. And then we'll be done. Company secretary for the next few minutes. Now, the Companies Act dictates that every company must have a secretary. That every company must have a secretary. But a sole director can also be a company secretary. If you are the sole director, if you're the only director of that company, then you can be a company secretary also. Good. How is a secretary appointed? How is a secretary appointed? Now, it is usual for the secretary to be appointed by the directors, right? On such terms as they may think fit. They can appoint anyone under their own terms, as long as they think that that person is fit to hold that office. Directors can also remove the secretary from office. They can also remove the secretary from the office. So they have the power to hire and fire the secretary. Now, the directors are required to take all the reasonable steps to ensure that the secretary is a person who appears to them to have the requisite knowledge and experience, right? They must be able to take all the precautions, right? To ensure that the person they appoint as secretary has both knowledge and experience. And any appointee to the secretary position must be one person who holds office as a secretary, assistant secretary, or deputy secretary of the company. Number 2, must have been a person who, for at least 3 out of 5 years immediately preceding his appointment, held office as a secretary, right? Number 3, a person who is a barrister, advocate, or solicitor. A person who is a barrister, advocate, or solicitor. Number 4 is a member of any of the following bodies. 1, we have CPS. 2, we have CPAs. 3, we have CIP, FA. But basically we also have ACCA. These are professional courses that have to do with law and accounting. Law and accounting, right? What are the powers of secretary? Remember, the secretary is the chief administrator of the company. Yeah. And in matters of administration, they have what we call on ostensible authority. They have what we call ostensible or apparent authority, or what we call also perceived authority to make contracts on behalf of the company, right? They are perceived to have that power that they can enter into contracts or make contracts on behalf of the company. And such contracts may include hiring office staff, contract for purchase of office equipment, hiring cars for business purposes, etc., etc. Now, although a secretary has extensive duties and responsibilities, there are a number of decisions where it has been held but that they do not have authority for particular acts. And such acts may include one, binding the company on a trading contract. They don't have that power. Borrowing the money on behalf of the company. They don't have that power. Right? Striking a name of the register or of the register of members. They have not that power. Summoning an annual general meeting in their own authority, they don't have that power. And therefore, it is important for them to be able to stick within their purview or the purview of their work. What are the duties of a secretary? What are they employed to do? They have a duty of documenting or ensuring that the company documentation is in order. They have a duty also of taking minutes. They have a duty of taking minutes. During meetings. You also have a duty of sending notices to members. They are the ones that must communicate with the members in case of any annual general meeting. They also have a duty of countersigning documents of the company. They can sign documents of the company. Now, that should mark the end of my presentation today. However, we continue with the discussion, which I'm putting up in a minute. Continue with the discussion. I am putting it up in a minute. Sure to participate. In the group forum. If there is any question, can also be asked there. Should be able to address it. You can be answered by those people who are in class early. For those people who came in late. Because I know some of you came in late. Right? Some of you are latecomers. You should avoid that habit. It is not good, otherwise you'll also be late in heaven. Right? Not good. It is not good. Not good habit. So a minute, I put up the discussion there. Yeah, you can start by sharing what you've learned. Just one thing. Just share one thing. Don't put a lot of issues. One thing that you'll not forget. one thing that you've learned today. I'll also post another question, which is likely to be an application question. I want to see how you can maneuver through that. No question here. So we go to the discussion forum. Go to the discussion forum and participate there.
Yeah, nacheka. You're laughing.